Hi, everyone. This is Carolyn Elephant, your instructor for the MyShingle Law Firm Startup AI Accelerator. And today we're going to be talking about the ethics and legal compliance issues in starting a law firm. Now, you might be wondering, why are we leading with this issue, ethics and legal compliance? And there's a couple of reasons for that. First of all, we're going to go through the ethics issues in sort of the logical sequence of the steps that you would be taking to start a law firm. And so it'll kind of give you a good overview of what you have ahead of you. But the second reason is you really want to troubleshoot these ethics issues up front, because you may discover that something that you intend to do maybe presents some ethical challenges. And it doesn't mean that you can't do them, but you need to do them in a certain way. And so that's the kind of thing you want to know up front, rather than after you've launched a campaign or a certain approach, and then you discover that it's something that you're going to need to change around 6 months in. So the other warning that I have for you here is that this is a long presentation. We're going to go straight through and cover all of the ethics and legal compliance issues. You may not want to listen to this all in one fell swoop, but maybe come back to it. Our future videos will be cut up, but the reason I'm doing this straight through is because I'll be applying for CLE credit, and it's easier to have the full recording. There'll also be a transcript, and you'll get the slide deck. And so if you don't want to sit through and listen to me talk you through the deck, you can go ahead and read through it. There'll be an opportunity to ask questions about this in either the course work sessions or through personal email with me. And so with that, let's go ahead and get started. So anyway, we're going to start with law firm names, the ethics of law firm names. Now, we're going to have a session with a couple of experts talking about the importance of name to branding. We're going to talk about that during our content and marketing week. It used to be that most jurisdictions banned trade names, and that was until around 2020. There was a lawsuit by a company, a law firm that's seeking to go by the brand Law HQ, and it challenged the restriction on trade names because it wouldn't have been able to have that name nationwide. And so now most states allow trade names as long as they're not false or misleading, and that's in ABA Rule 7.5. So for example, a false or misleading name would be if you're a solo practitioner, you don't have any attorneys working with you, and you call yourself Doe and Associates, or if you call yourself your firm by a legal clinic or imply some connection to a government agency. There's also some jurisdictions like Florida that don't like these names that are considered undignified or aggressive, like the pit bull lawyer or shark lawyer. That bar has said that the name doesn't encourage informed decisions by clients. So this is the kind of thing that you can assume that you can use a trade name, and there's a lot of reasons to use a trade name. You just want to make sure that the one you select is permissible in your jurisdiction. The next question is a legal question. Do you need to trademark a law firm name? And again, we're going to have a whole presentation on this, but just in terms of a big overview, usually the need to trademark a law firm name is mitigated by bar rules, because bar regulations limit you to practice state to state. And so there's a reduced likelihood of confusion. If you're the Integrity Law Firm in California, chances are you're not going to be confused with the Integrity Law Firm in Maine, just because the Maine clients are not going to be looking at a California firm, and the California firm isn't going to be able to practice in Maine. However, you may run into a situation where you wind up with the same name in the same practice area. That was the case with two law firms that were called the O'Keefe law firms. They were both in Illinois. And there was a trademark dispute that was eventually resolved between the two of them. The one thing that you do want to look into trademarking are taglines and unique names. And that's something you may want to do down the line. It's questionable as to whether it's something you want to do right up front, just because it can be a distraction. But again, we've got a couple of experts who are going to be doing a deep dive into those issues. And so you'll have more guidance on that, the issue related to trademark of your law firm. So another ethics issue that can arise comes up if you're starting a law firm after having worked at another law firm. And the rule there, as most of you know, law firms aren't allowed to really have non-competes. You can't prohibit an attorney from starting practicing law at another firm or taking clients with them, because the theory is that clients have unfettered discretion to the attorney of their choice. And so a non-compete or a prohibition on that would interfere with the client's right to a lawyer of their choice. There was a recent ABA decision in 2019 that clarified that lawyers can't even require a minimum advance notice of departure. So in terms of leaving, what the ABA guidance says is that if you're leaving a firm, so for those of you who are currently at a firm, you can tell clients at the time of departure at the same time that you inform the firm that you're leaving. In an ideal situation, in terms of notifying the clients, both the attorney and the law firm would send a joint letter to the client indicating that the attorney is leaving and providing contact information. That doesn't always happen, and the ABA rules allow for unilateral notice if the firm isn't willing to tell clients. But the one thing that you don't want to do is to start soliciting law firm clients while you're still working at the firm. That can put you in violation of a partnership agreement if you have one, and it also can be deemed unethical conduct. Now, let's say you're working at a firm and you wanted to start a law practice on the side. In that situation, you've got moonlighting or part-time practice considerations outside of the law firm. And these are things that courts take very seriously. So in terms of legal considerations, you've got to look at what your contract and your employment contract says. Does it prohibit outside work? There are some jurisdictions like DC that recently made it very difficult for an employer to prohibit any kind of moonlighting or work on the side. But that said, in other jurisdictions, an employer may be considered perfectly reasonable in telling attorneys that they can't engage in any kind of outside work, not just necessarily a competing law firm, but even something like doing TikToks on law or being an influencer. So those are some of the legal considerations. In terms of ethics, again, courts take this moonlighting very seriously, because when you're working for a law firm and doing your own practice on the side, you can potentially expose your firm to malpractice allegations, to conflict of interest. So here you see there's some examples of attorneys who were sanctioned for dishonesty by not disclosing a practice to the firm. California bar says that maybe moonlighting is okay, but it can't conflict with you. You've got to do a conflicts check. And then the other thing is that you also want to make sure that when you do work on the side, that you really maintain a separation between the firm that you're running and your law firm. The last thing you want to do is expose your firm to malpractice liability. That's probably not a great way to get your own firm off the ground. My own feeling is that if you're going to start something on the side, honesty is the best policy. Disclosing what you're doing to your employer, you might find that they support it. But again, you have to judge your own situation. Just keep these considerations in mind if you're going to be starting something on the side when you're currently working at another law firm or in-house counselor doing something law related. Okay, unauthorized practice of law issues. These are always very confusing to people. I try to break it down in a logical fashion. And so one of the questions you're going to do, the first question you're going to ask is really a foundational question as to whether you're doing unauthorized practice. Are you licensed in the state where you're physically doing the work? So if yes, then you're not engaged in unauthorized practice of law. If you're a New York attorney, you have a New York law firm, and you're practicing there, it's no issue. Now, let's say you are licensed in another jurisdiction, but you have an office in a different state. And so then you would look to the guidance in the ABA Formal Opinion 495. So essentially what you can do, what is typically the ABA cases, let's say you have let's say you're licensed in New Jersey and you're working out of an office in New York. The ABA rule says that if you don't hold yourself out as a New York attorney, if you only advertise to New Jersey clients, if you only serve New Jersey clients, that's okay. Now, that's the ABA guidance. States are different. Up until very recently, Maryland had a hard no on something like that. If you had an office in Maryland, but you were only licensed in Virginia, and even if you held yourself out as practicing in Virginia only, Maryland still said you had to be licensed in the state of Maryland. That's something that has changed. The other exception to that rule is if you're doing a purely federal practice, if you're engaged, if you're doing bankruptcy law, trademark law, then it doesn't matter if you're licensed in the jurisdiction where your office is located, as long as your practice is limited to federal law. And that's because federal law preempts state regulations. You can't have a state putting restrictions on a federal practice area. The other thing to keep in mind is it's not just related to a physical presence. You might have a situation where you're not licensed in the state of New York and you don't have a physical office there, but you put up signs that are targeting New York state clients. You are in New Jersey and you say, we can represent New York clients in New York courts. I don't know why you would say something like that, but if you are targeting clients in a jurisdiction where you can't practice and very specifically targeting them, you could also be dinged for being engaged in unauthorized practice of law. Now, the next thing that you want to look at when you're doing an analysis of whether you're involved in unauthorized practice of law is what type of work you're doing. So is the work considered practice of law that would require a state license? And so, as I said in the last example, federal practices like immigration, bankruptcy, or trademark preempt state license requirements. So for that reason, you wouldn't have unauthorized practice without a state license. If you're doing things like reviewing or advising clients on matters in other jurisdictions, so let's say you're barred in New York and you have a New York client who asks you to research California employment law or Texas trust and estate law, that's going to be okay too, because you're doing the work in the state where you're licensed. Now, ethically, I just want to make the point that ethically something like that is okay. You still want to think about the malpractice and competency situations. If you're in New York and just doing some, very 30,000 foot survey of laws of other states, that's probably going to be okay. But, if you've got a New York client who has a California subsidiary and is asking you to analyze specific employment law and it's something you're not familiar with, you can probably go ahead and do the research on it. The question is whether you're going to be committing malpractice while doing it. So it's not an ethics issue, but it's a prudence malpractice issue. Other things like incorporation filings, that's generally not considered the practice of law in most states. And so for that reason, if you're in New York or if you're in Connecticut, you can generally incorporate a company in Wyoming or Delaware. Those are two jurisdictions that sort of have this national approach. Any case that's involving court filings is going to be unauthorized practice unless you're licensed in the jurisdiction. And then there's this whole host of other matters, things like closings and negotiations and pre-suit demands, where it really is not clear whether those fall within the parameters of being practice of law. There are some real horror stories. For example, there is a case involving a Colorado lawyer who tried to help his in-laws in Minnesota resolve a debt collection matter. So he called up the attorneys in Minnesota. He tried to negotiate something for him. And the Minnesota attorneys reported this Colorado lawyer to the bar. They said he was engaged in unauthorized practice, and the court agreed. So no good deed goes unpunished. But again, in that situation, even though he'd never filed suit, and he was just trying to resolve an issue through outside of court proceedings, he still got dinged for unauthorized practice. So again, if you're doing something in these areas like negotiating or pre-suit demands, you really need to look closely at the laws in your state or the practices in your state to determine whether they fall within the bucket of law law-related activities for which you need a license or whether they're outside the scope of that. And it's going to be a very state-specific inquiry. There was recently some guidance on multi-jurisdictional practice by ABA Formal Opinion 540. That just came out in April of 2023, and there's a longer summary at MyShingle. So one of the questions that's come up for attorneys who practice in multiple jurisdictions is, which jurisdictions' regulations do I follow? I am licensed in 3 jurisdictions, in Maryland, DC, and New York. I tend to be a little cavalier about following my ethics rules, but I haven't really experienced conflict. But in some situations, there could be a conflict. For example, some jurisdictions have different rules on referral fees. You know, if you practice in Georgia and Florida and you want to make a referral in a certain state, that raises the question of, you know, if the rules are in conflict, what do you do? So the conventional wisdom had always been, you just go with whichever bar has the strictest rule, that's what you have to comply with. And that was problematic because, you know, if you are in Florida and if you're in 2 jurisdictions, state A and state B, and A has very liberal practices on referral fees and state B doesn't, you shouldn't lose the ability to generate referral fees just because one of the jurisdictions with your practice doesn't allow it. So that's the whole point of Formal Opinion 540, is to kind of help sort these things out. And it's a pretty detailed opinion. It's probably one of the best ethics opinions I've read, just because it goes through a lot of different scenarios and there's a lot of practical information and practical guidance. But essentially what it does is it starts with the premise that Model Rule 8.5 is kind of the rule that you look at. And 8.5 says that if you're practicing in a state, if you're before a court, you have to comply with the ethics rules of that jurisdiction where the matter is before a particular court. So if you are licensed in New York and you've got a case that you're handling in New York, you're going to be bound by ethics rules of New York for that jurisdiction. And even if you're licensed in New Jersey and New Jersey's rules are completely different, doesn't matter. The rules are pretty clear. You comply with the ethics rules of New York when you're practicing before court in New York. Now, for other conduct, like if you're not before a court, you have to comply with the ethics rules of a jurisdiction where the predominant effect of the conduct occurs. Predominant effect is kind of an amorphous term. And so one thing this ethics rule does very well is give examples that help to define predominant conduct. So for example, if you're filing a fee agreement, fee agreements are usually governed by the ethics rules of the jurisdiction where they're executed. So if you are if your office is in New York and you're representing a client in New York, the ethics rules of New York will apply. That's where the agreement was executed. If you're representing a New Jersey client in a New York case and the New Jersey client comes to New York, even if you're licensed in New Jersey also, if you're signing that agreement in New York, the New York ethics rules will apply. If there's any confusion, you feel that there's some confusion or you want to have some clarification, you can put into your retainer agreement. This agreement is governed by the ethics rules or the professional code of conduct of X state. The next thing, law firm ownership structure, that's governed by the state where the firm is located. So for example, in states like Arizona, you can have non-lawyer ownership, same in Washington, DC. So if you are barred in states, in states like New York and New Jersey that don't allow law firm ownership, but you open up a firm in Washington, DC, you can have non-law firm ownership in the state of Washington, DC, at least under Formal Opinion 540. Now, there have been some state rules that have said that, for example, like a New York attorney can't be a partner in a firm that has non-lawyer ownership. There had been a rule or an ethics decision on that was kind of on the books. So the point here is with something like law firm ownership structure, if you are, want to be a part of this movement towards non-law firm ownership and be part of a firm like that, you want to make sure that your state follows the same guidance as the ABA Formal Opinion 540, or that it adopts ABA rules, because your state may not allow you to do that. So that's something where you'd want to see what your state, if your state will prohibit you from participating in that type of structure. Professional misconduct governed by the state where the incident occurred, that's fairly straightforward. Confidentiality is governed by the state where the disclosure would have the predominant effect. So if you inadvertently disclose client confidences, and you are representing a corporation in Pennsylvania, but you also practice in New Jersey, it's going to be the Pennsylvania rules that are going to apply, because that's where it's going to have predominant effect. And, again, that would be true even if the disclosure, or, if it's a Pennsylvania company, but the Pennsylvania company is involved in litigation in Oklahoma, and there's disclosure and you're, barred in both states, it might still be Pennsylvania that would, confidentiality rules that would apply. And the last thing is for choice of law analysis for lateral hires. This is really something that probably doesn't apply so much to a solo or a small firm owner, but the choice of law analysis is going to depend on the nature of the conflict of interest. And so this is essentially for a situation of which state, if you're moving from one multi-jurisdictional firm to another multi-jurisdictional firm, and there are questions about whether your clients pose a conflict of interest, you're going to assess what the nature of the conflict is. That's not really something that's relevant to being an owner at a law firm. So virtual practice also raises ethical considerations. Especially, there's always been a longstanding tradition in the legal profession that lawyers, have a physical presence. But in the pandemic, a lot of that has changed, and lawyers by necessity had to offer virtual services or decided to go completely remote. ABA Formal Opinion 498 talks about some of the ethics considerations that apply to virtual practice. There's technology considerations. You want to use your tech prudently, be able to access client files. Clients are going to need to access things through the cloud. And so you've got to be very prudent in choosing your service provider. Same with virtual meeting platforms. You want to be able to, look at the terms of service for exchanging documents. I mean, a lot of these considerations that relate to the ethics of virtual law practice are very similar ones that apply to use of technology, because a virtual law practice is heavily reliant on technology. The one thing is with virtual law practice is that trust accounts do need to comply with all the jurisdictional requirements. At least that's what ABA Formal Opinion 498 said. I don't know if there's any change to that as a result of that ruling that we just discussed. You want to have appropriate supervision. The other thing with virtual law practice is it's really something that needs to be disclosed to clients. If you have an office that you are not physically present in, you want to tell clients that, you have something like meeting by appointment only, or something to signal to them that, that if they go to this particular location, people probably aren't going to be there. So you don't necessarily have to tell clients like where you're working, but you want to avoid situations where they show up at a building and you're not there. And also, if a client asks you specifically if your firm is virtual or if you work out of an office building, you really should be truthful in disclosing to them the nature of your practice, and not be deceptive about it. Outsourcing is another thing that solo and small firms might do. And this is something that has been addressed 15 years ago by ABA Opinion 08-451. Again, a lot of this is common sense. It's basically outsourcing is permissible if lawyers supervise and also disclose and obtain a consent from clients. In some of the materials we have on fee agreements, there are some sample provisions that I've included that you can put into your engagement agreement if you intend to outsource. It's sort of a generic passage that you would put in to disclose that you might be using outsourced services outside of your firm. And that's really something, again, that is supposed to be disclosed to clients. In terms of fee agreements for outsourcing, if you outsource to a contract attorney in all jurisdictions except Texas, and this is something that may have changed, you can mark up the cost of the service. So if you pay a contract attorney $100 an hour, you can build the contract attorney out for $200 an hour, because it takes into account the oversight and the other costs attendant to delegating the work, as long as the overall fee is reasonable. And usually when you're using an outsourced attorney, they're more experienced, they're working for less than an associate would, so the fee is always invariably reasonable. And the other ethics opinion is that you can't recoup outsourced costs associated with overhead. So something like a receptionist service is traditionally considered to be an overhead cost. It's a cost of doing business that you need, whether you are serving one client or a million clients. And so in that situation, just because you outsource the receptionist service, that doesn't somehow convert the nature of it into a billable expense. And so you still can't pass on the cost of, your outsourced answering service to clients, except, in very special situations. I suppose you could have a situation where a client literally calls like 100 hours a month, and maybe you could assign some of those added costs on top of it. But generally speaking, anything that's outsourced as overhead, receptionist services, admin costs, you really can't pass on to clients. Okay, next is the ethics of billing. All jurisdictions without exception require some kind of written engagement agreement if you want to be able to recover the cost of engagement. Like I said, I will be sharing a very extensive resource on engagement agreements and different clauses and phrases and samples that you can use. And we'll also be working on developing them in the course. So this is just really mostly for an overview. If you're billing hourly, you're going to need to have a trust account. If you get advance payment, you're going to need to give description of time and work on the invoices. If you're billing flat fee, and we'll be talking more about flat fees, the advance payment into the trust account is not required in some jurisdictions where flat fees are treated as earned on receipt. So there are some jurisdictions, I think like Georgia or North Carolina, which say that if somebody pays a flat fee up front, it can go right into an operating account. There are some other jurisdictions that like Maryland that allow clients to consent, clients who are charged a flat fee to consent for it to go directly into an operating account. And that's something you want to disclose to the client in the engagement agreement if you want to be able to put the flat fee directly into the trust account. But there are other states like DC that have made very clear over and over again that flat fees paid in advance need to go into a trust account. And that can be problematic. I mean, if somebody pays you, $15,000 for a criminal case, and the case, technically speaking, if you're paid that $15,000 under DC bar rules, you can't take that money and pay yourself until all of the work is done. And a criminal matter, even with speedy trial rules, can still go on for a year. There are other types of matters that could go on even longer. So if you find yourself in a jurisdiction that's very strict like that, what you can do is you can establish milestones that would allow you to withdraw the fee in stages. So in the criminal case, example of the criminal defense case I gave, you could charge $5,000, after the retainer agreement is signed, and you enter your appearance at a preliminary hearing, you could charge $5,000 at that stage. You could charge another $5,000 at a stage, another stage in the case, and then the full fee after trial or after the case is resolved. So again, I've got examples of that kind of milestone language in the companion materials. But that's something that you really want to do, because otherwise you're going to wind up holding that flat fee and you may not be able to withdraw it for months and months. Now, it's a different situation if you're doing maybe something like estate planning where you have a 1 or 2 month turnaround. It's not a big deal to put money, to collect a $4,000 fee for trusts upfront, put it in the account, and then withdraw it a month later after you've completed the work, or 2 months later. But if the cases go on, for a long time, like a client doesn't return materials or you have a lot of back and forth, you could still be waiting a long time to recover that fee. So you always want to consider whether the milestone approach is one that is workable for you. Next issue regarding to, excuse me, the ethics of billing is refundability. So the general rule that I'm sure you've heard is that there's really no such thing as a truly non-refundable fee except for a true retainer. And what a true retainer is when you retain somebody specifically to have them available. So you're going to be investigated by the SEC, and you call the lawyer at the biggest law firm in town. You say, I'm going to pay you $50,000 a month just to have you available and conflict free. So you're paying the person, you're essentially paying that person not to take any other cases, not to get involved in conflicts, and just to be available for you. So in that situation, if they pay you $50,000, if you're paid $50,000, or if the lawyer's paid $50,000, and the case is solved 10 days later, they can keep that fee. That's a very rare case, that true retainer. And if you look at some of the case law on it, you'll see that courts are interpreted very narrowly. Any other kind of fee is something that has to be refunded. Any other kind of fee is at least vulnerable to refund. It doesn't mean it has to be refunded. It just means that it could potentially be refunded if the result is unreasonable. So in a situation where, say, somebody comes in, they pay $10,000 for divorce, and then the person decides 2 days later that they don't want to get the divorce anymore, and you say, no, I'm keeping that $10,000 retainer. Chances are, if that person went to the bar, you would have to give that money back, because it was $10,000. You can certainly keep part of it, if you opened up a file, if you started reviewing papers, but chances are you're going to have to give back the bulk of it, because after 2 days, it's hard to say that you did the work. The same thing, like a $50,000 fee for criminal defense, and the lawyer just sits on the case for a year, and you decide to hire another attorney, they're going to have to refund the bulk of that money to you. Now, the one area where a refund isn't justified and where people think they demand it is if you obtain a result that's quicker than anticipated and the client balks because they thought the case was too easy or they overpaid, that's not grounds for a refund. Again, in a criminal defense situation, if a client pays you $15,000 and you make a couple of phone calls and you're able to get a case, a drunk driving case, or a securities fraud case dismissed in a couple of weeks, you're still entitled to that fee, because what they're paying for is the result. And you got that result. And even if the result was quicker than anticipated, it doesn't mean that your fee is unreasonable. So, in that type of situation, if you've been paid a flat fee and a client balks that it's too high because the case didn't involve that much work, your response is, look, you paid for the result, and this is what the result was, and that's the value that you received. Now, and many bars will back you up on that type of outcome. Not all of them will, but that's just something to watch out for. Don't feel that you've got to give a refund back just because the result was quicker. And again, that's the whole point of the flat fee, is to encourage efficiency. And things can go the other way too. It's not like the client, if you've taken a $15,000 fee and it turns out the client's case takes 80 times as long as you thought, you're not going to bill them. You'd be prohibited from billing them for the extra because you are stuck with the benefit or with the bargain that you made. And the same is true for clients. For contingency fees, the one thing you want to make sure of is, first of all, that the percentage you're recovering is consistent with applicable law. Some states put a cap on certain contingency fees. So if your state caps contingency fees at 35% of the recovery, and your retainer agreement says you're going to take 50%, that's going to be a big red flag. And contingency fees often require certain explanation in the agreement, in your retainer agreement. Again, it's going to depend on the jurisdiction you're in. Sometimes you have to say that the outcome isn't guaranteed. Sometimes you have to tell clients that, if they lose the case, they're not going to owe you money. There's a bunch of these sort of magic language that's very jurisdiction specific. So if you're charging contingency fees, you just want to make sure to get a good model agreement from your jurisdiction, because the thing is if your retainer agreement is invalidated in any way, you stand to lose your fee, and that's problematic. That's very problematic. And I don't think we talked about, I think there's a slide later for the ethics of referral fees. The ethics of bill financing. So this is different from litigation funding, but there are many services that provide financing to clients that an attorney can offer. So it's essentially like if you've ever had kids, or if you yourself have ever had orthodontia work, the orthodontist will usually offer some sort of financing agreement through a bank or a service. And there are services like that in legal too. I think one of them is called Justice for Me. I can't think of the other ones off the top of my head, but essentially what happens is a client can apply to get financing through those companies. And the question had arisen as to whether that was permissible. And the ABA opinion 484 says yes. Lawyers can refer clients to those kinds of fee financing companies. It helps expand access to justice, as long as the attorney doesn't have an interest in that financing company. So if you own a financing company, or if your spouse owns a financing company and you're channeling clients to that company, that's probably going to be ethically impermissible. But otherwise, again, many of these lawyer financing companies are perfectly permissible. And some attorneys have used them successfully, some not so much. Something that could be worth looking into depending on your client base. And if you think it's something that would be helpful to them. Ethics of passing credit card fees to company. So the first thing is at one time, many states did not even allow businesses, not even law firms, but just businesses, to pass surcharges through to clients. That was considered to be inappropriate. Today, surcharges can be passed through in all states, but Connecticut and Massachusetts. So that's the law. So legally, in most states, you can pass it through. What are the ethics? So the ABA originally had ethics ruling on credit cards back in 1974. It said, yes, you can use credit cards, but you can't use them if they increase fees to clients. And so that implicitly prohibited lawyers from passing on surcharges, because that would technically increase the fee to clients. The ABA retracted that position on surcharges in 2000. And so the ABA rule is now that you can pass surcharges on if you want to. The majority of jurisdictions agree with that. They say you can pass on the credit card surcharges as long as you disclose it and have client consent. There is still a minority of states like Michigan, Alabama, and maybe a couple of others that say that you can't pass the surcharge along because it results in paying more for the fee or legal services. For me, The credit card surcharge issue is again more an issue of client policy and prudence rather than ethics. Many clients may not like having to pay a surcharge in order to use a credit card, and so you have to think about whether and data has shown that when clients pay by credit cards, attorneys get paid, whereas if you're accepting money or payment in other ways, you may not get paid as quickly, and you may wind up writing off costs. So you have to sort of balance out, and many attorneys just consider the surcharges to be a cost of doing business. And if the surcharges are really eating into it, just raise your fees a little bit to cover it, but don't necessarily pass the charge on to a client who may not, because a credit card may be the only way they can afford to use your services, and charging a surcharge just kind of adds insult to injury. So just think about whether, how much money it's costing you to pay that surcharge yourself when you make a decision. Crowdfunding a law firm. This is a question that came up in New York a couple of years ago by some enterprising immigration attorneys. They wanted to crowdfund in order to just raise some money for some of their startup costs. And the New York Bar said that, yes, crowdfunding was okay as long as the people who were funding this campaign didn't get some sort of ownership stake in the law firm. Okay, this is the ethics of referral fees that we had mentioned. I should have mentioned this in the context of billing. So the first question that comes up with referral fees is, can you share a fee with non-lawyers? In Arizona, you can, because ABA Model Rule 5.4 prohibits the sharing of referral fees with non-lawyers. That was repealed in Arizona, and so you can share referral fees with non-attorneys. In most other jurisdictions, you can't. So in terms of lawyer-to-lawyer referral fees, most states do allow lawyers to pay referral fees. I see a lot of misunderstanding about that on listservs. There's a lot of attorneys who say, oh, my state doesn't allow us to pay referral fees. I don't think that's necessarily true. There usually are some conditions to it. In virtually all jurisdictions, the referral fee has to be disclosed to the clients. And then in other jurisdictions, in addition to this disclosure, the referral fee has to be proportionate to the work performed, and the overall fee has to be reasonable. And you want to write those terms into your retainer agreement. And again, I've got examples of retainer agreements that include referral fees and the kind of language you need to keep in them. If the referral agreement is not disclosed to clients, there are a number of cases where courts have invalidated a referral fee because it wasn't disclosed to the client in writing and the client didn't approve it. So it's definitely something that you want to pay attention to. And the referral fee in proportion to the work performed, there are ways that you can create a referral fee and have the referring attorney still stay involved enough to justify this proportionality requirement. So don't assume that you can't pay referral fees. Also, referral fees are most common for personal injury, but you can do referral fees for any type of practice area. And if you think that it's a good way to help encourage business, look at referral fees as a way of doing that. Because if you have more business, if you're a savvy marketer, or if you're an insane networker and you get a lot of cases and you want to send them out to other firms, there should be some sort of monetary reward from that, because it took you time to build up that kind of network that yielded referral fees. And many attorneys who receive cases as a result of referrals realize that they're saving on marketing costs, and that clients who are referred are much, much more likely to retain than those who you get from Google searches or from other types of marketing. So there's definitely a willingness to pay referral fees by the receiving attorney, and there's value that the referring attorney provides that should be compensated. So I don't have a problem with referrals. I think that lawyers should use them where possible, because they can be a nice steady stream of income or side income if you are able to refer out good cases to other attorneys. Okay, so marketing ethics considerations. We could talk about this for hours and hours and hours. We're just going to hit on some of the high points. The general rules are really common sense. Lawyers can't make false or misleading communications about their services, and it's pretty straightforward what's false and misleading. You can't give a payment or an item of value in exchange for a recommendation, so you can't pay somebody to give you good reviews, or you can't give really lavish gifts to referral sources or pay a referral source a kickback every time they send you a case, unless of course it's a referral fee that's codified in a letter. And then also you can't directly solicit clients. So you can't, start calling people on the phone and ask if they want an estate plan or something like that. State rules vary very widely on things like use of testimonials, review of website content, participation in platforms. Avo Ask used to have a platform where an attorney where consumer could hire an attorney for a flat fee through the Avo site and then split the fee with Avo, or it could ask a question and a client could pay like $50 and ask a question. And if attorney answered it, they would get as part of the $50, Avo would get some of it. State said that was, unauthorized or unethical fee sharing with a non-lawyer. So you want to sit down and look at whatever your state version is of Rule 7.1 to see if there's any marketing practices that you can engage in. This is one thing that it's cumbersome, but you really want to look at it yourself. There's so much inaccuracy and so many people who have, sat through a CLE and they understood the person to say one thing about a practice being prohibited. Others found it different. You really need to look at the rules yourself, because there's just a lot of misconceptions. And if you're really not sure, you can always call your bar hotline and get a straight response. So what I think is more challenging, and the problems that I've seen for attorneys with marketing, isn't so much ethics violations, but attorneys forget that they're also small businesses, and they're subject to many of the same rules and regulations that any other small business is. And bars don't seem to talk about those issues. They're so focused on ethics. So, for example, you need to make sure that your website has a privacy policy in terms of service. That's important, under FTC and just general consumer and privacy laws. Does your website have disclaimers? Again, any disclaimers that are required to be disclosed under consumer law or FTC. You've got to conform to different privacy laws. There's many states that are enacting privacy laws all the time. And if your website is going to be published in those states, you need to make sure that it conforms to those requirements. You need to look at the images of your website and your copy and see if it complies with applicable copyright laws. We're going to be talking about copyright a lot, and so far as it relates to AI, because that raises some additional areas of concern. But I think just a few weeks ago, I saw on a website that there was an attorney who had hired a web marketing company to do her website. They used a photo that may have been subject to copyright and put it on her site, and she's the one getting the cease and desist letter. So these are really things that you need to pay attention to. If you're hiring a web company, you need to make sure that whatever stuff they're putting on your website is either not subject to copyright law or that they have the licensing rights to use it. Your website needs to disclose affiliate relationships or benefits in exchange for reviews. I know that there was a time when attorneys would offer, a discount to clients, or, $20 if they gave a review of the law firm. And and it didn't matter. They weren't told to give just a favorable review. They were just told to give any kind of review, but you still, if you're paid to provide a review of any type, the FTC wants that to be disclosed, because a person who's given money is more likely to post a review, and they're probably more likely to post something that's favorable. So that's something that attorneys don't think about. You need to make sure your website is ADA compliant. I don't think we've yet reached a point where attorney generals or prosecutors are going after companies for ADA violations. We are starting to see some, the cottage industry of lawsuits maybe suing the types that have sued small businesses for lack of ADA access. We may soon start seeing that with lawsuits involving websites. So you want to make sure your site is ADA compliant, and there are services that can do that. And I think as AI becomes incorporated into website development and design, we're going to see a lot more advancements that make it easier to be ADA compliant. If you're offering subscription services, which is something we're going to talk about, do they comply with state law and FTC requirements on cancellation policies? The FTC requires notice before you it requires companies to give notice before a subscription service auto renews. That's something that applies to you if you offer a subscription service too. And then you need to make sure that any emails you send or newsletters are compliant with the Can-Spam Act. So these are all laws that apply to any small business. They apply to you as law firms too. This is just sort of an overview. Again, I've got some materials for compliant privacy policies and disclaimers for websites. But if you just pick up any, reputable small business handbook or read up on some of the lawyer blogs that advise small businesses, you'll be able to get up to speed on a lot of these issues very quickly. You won't find too many CLEs that discuss these issues in detail, though, which is unfortunate. And then there's the last ethics rule, the ethics of technical competence, which is something that we'll be discussing in the presentation on ethics and legal issues related to AI. But essentially, I think there's about 30 jurisdictions now that have adopted a duty of technical competence, which is to maintain requisite knowledge and skill by keeping abreast of changes in the law and practice, including benefits and risks associated with relevant technology, engaging in continuing legal education, complying with legal education requirements on technology. And again, some states have specific technology competence requirements. And essentially, it's an added burden, but you need to stay on top of the technologies that you use to protect your clients. You need to be familiar with how some of these technologies work, what the terms of service are, and what these companies are doing with data that you provide from your clients. These are all the kinds of questions that you want to ask of companies as part of your duty to technical competence, and also to protecting your clients' interests. So this is something in the era that we practice now that's become very important. And that concludes our overview of the ethics and legal issues related to starting a law firm. I know that there was a ton of information here. And like I said, I hope that you watch this in small pieces and not straight through. If you have any questions about anything in this presentation, you can either raise them at the work session or by email to me. And like I said, there will be some supplemental materials I'll be provided. I know it's a lot to digest. Anyway, thank you for sitting through this module, and I'll see you in class over the next couple of weeks.